And we will, for the next moment, since the staff has not ordered lunch for us with some intention, I submit, we will now proceed back to the public session agenda. And our status is we have the consent calendar ahead of us first. And so we'll proceed through the agenda in the order in which it appears. Is that right?
Yes.
Director, are you ready for the?
Yep. We have let everyone that's in the lobby and making it so it's public and they can just come in.
Thank you very much for that process. We'll now proceed to the consent calendar, which appears at near the top of the public session agenda for January 24. The first question is, does any commissioner want to pull an item off that consent calendar? Hearing and seeing no request for same, Vice Chair, please.
I move that the commission approve the consent calendar on the public agenda as presented.
Thank you, colleagues. Any questions, comments? Hearing and seeing none, the administrator will call the roll on the consent calendar for January 24th.
Commissioner McCauley.
Aye.
Commissioner Burke.
Aye.
Commissioner Thompson.
Aye.
Commissioner Payne.
Aye.
Commissioner Resendez Gutierrez.
Aye.
Chair Fiscom.
Aye.
Motion passed 6-0.
Hey, colleagues, no lobbyist penalty correspondence today, no lobbyist client penalty correspondence, no SEI penalty correspondence. Director, remind us about our approach on stipulated final orders under consent calendar.
These are all stipulations for letters of education. You have the option of approving them en masse with one vote to approve the items on the consent calendar.
Thank you.
But if you would like to pull any, you may do so.
Thank you very much. I thought that was the case. Colleagues, any on this part of the consent calendar, stipulated final orders, items 6 through 11, any commissioner want to pull an item off for separate individual consideration? Hearing and seeing none, I'll accept a motion for the stipulated final order consent calendar. Vice Chair.
I move that the commission approve the proposed stipulated final orders presented on the consent calendar as the final orders in those cases, and that the chairperson be authorized to sign them as such.
Thank you, Vice Chair. You've heard the motion on the STIP consent calendar. The administrator will call the roll, please.
Commissioner Burke.
Aye.
Commissioner Thompson.
Aye.
Commissioner Payne.
Aye.
Commissioner Resendez Gutierrez.
Aye.
Commissioner McCauley.
Aye.
Chair Fiscom.
Aye.
Motion passed 6-0.
Thank you, colleagues. We'll now move to item number 12 on our public session agenda, a stipulated final order where a proposed civil penalty is involved. The matter involves Mr. David Stockdale. Is he going to be online in a minute?
No.
He's not online.
Not,
Thank you.
That one's not appearing.
Thank you very much. I hadn't lost sight of my page with that effect. Here it is. I found it again. Well, I'm in good shape again. Okay, our investigator for this matter is Investigator Sullivan. Please proceed.
Yes, I'm Investigator Josh Sullivan for the record. Agenda item number 12. This is a stipulated final order for David Stockdale, who's the city manager for the city of Umatilla. In this case, it's related to a conflict of interest and prohibited use of office, in which he stipulated to agree to the violation and pay a civil penalty of $350.
Thank you very much. Any questions for our investigator on this matter before us? Item number 12. Hearing and seeing none, Vice Chair, please.
I hereby move that the commission approve the proposed stipulated final order as the final order in this matter, and that the chairperson be authorized to sign it as such.
Thank you. Administrator will call the roll. Item 12 on our public session agenda, please.
Commissioner Thompson.
Aye.
Commissioner Payne.
Aye.
Commissioner Resendez Gutierrez.
Aye.
Commissioner McCauley.
Aye.
Commissioner Burke. Commissioner Burke.
Mr. Burke, are you still here?
Yeah, I was having a problems unmuting. My apologies. Aye.
No problem.
Chair Fiscom.
Aye.
Motion passed 6-0.
Okay, colleagues, we'll keep moving forward to no default final orders. We have two reports of investigations. The first is item 13. Is Mr. Hollins going to be online
Yep, and
with
yes.
us? And he is online. Mr. Hollins, are you here? Can you identify yourself for the record, Mr. Hollins?
Yes, I am Robert Hollins.
Thank you. Can you hear me?
Yes, I can.
Thank you very much. I'm Dave Fiscum. I'm the Chair of the Ethics Commission. We've come to the matter involving your name under reports of investigations. Our process is going to be to hear a report from our investigators, then we'll hear from you. If you choose to make any comments to us, then we'll move toward a decision. So that said, our investigator is Josh Sullivan. Mr. Sullivan, please proceed.
Yes, thank you, Chair Fiscum and Commission. This is Investigator Josh Sullivan for the record. I'm presenting agenda item number 13. This is an investigation report for Robert Hollins, former Portland Police Bureau detective. A case was opened in preliminary review for this case on October 3rd, 2019, based on information in an article published in the Oregonian, which indicated that Portland Police Bureau Detective Robert Hollins may have violated Oregon government ethics law by using his position to drive a city-owned vehicle for extensive personal use while off duty. And by doing so, Mr. Hollins obtained a financial benefit or avoided a financial detriment, which would not have been available to him except for his official position. At the Commission's November 22nd, 2019 meeting, the Commission considered the investigation presented in the report and moved the case to investigation. During the investigation, Mr. Hollins requested a time waiver because he had ongoing litigation with the City of Portland relating to the matter and was concerned that the Commission action could be prejudicial to that ongoing litigation. The Commission agreed to the time waiver and the litigation with the city was continued until 2022. It was only when the Commission staff learned of Mr. Hollins' settlement with the that the investigation was reactivated and the investigation was completed. In 2018, Mr. Hollins was investigated by the Internal Affairs Office of the PPB for allegations of excessive personal use of a city-owned vehicle. Generally, the PPB regulations prohibit personal use of a vehicle and use of a vehicle for vacations. However, the PPB regulations specifically allow detectives to use a city vehicle for personal use because they are subject to callback. Therefore, under the official compensation package, a detective may use a city vehicle for personal use. Although the PPB initially found Mr. Hollins in violation of PPB policy, the City of Portland later paid Mr. Hollins a settlement and agreed that he had been made whole and received restitution for his use of city resources, including the mileage and gasoline usage investigated in 2018. Given the lack of clarity in the PPB policies and the settlement by the City of Portland, the investigation or the information in this investigation is insufficient to find that Mr. Hollins used a city vehicle in a matter which was not included in his official compensation package as a detective. Thus, the information is insufficient to include that Mr. Hollins used his official position to obtain a financial gain or avoid a financial detriment. Based on this information, the Oregon Government Ethics Commission should find that there is not a preponderance of the evidence in this case to establish that Robert Hollins violated the prohibited use of office provisions in Oregon government ethics law, and that in order that the case be dismissed.
Thank you, investigator. Any questions for our investigator? Hearing and seeing none, I have one. I'm not sure how to ask it. I'm looking at the bottom of page 6 in the report, or page 64 in our total document, and the top of page 7. Do you have any further context for those two or three paragraphs, investigator?
Yeah, at the bottom of page 64.
Yes, interview with the PBB investigator, et cetera.
Mhm.
Over when asked if he used his own funds to get gas while he drove to Seaside, Mr. Hollins replied no, et cetera. Any further context on that?
That
issue
is
there?
yeah, the issue there is the initial allegations was that he used the vehicle and gas, the city resources, for his own personal benefit. However, the way that PPB policy is for detectives using city resources, the vehicle specifically, for personal use, it allows them to do that if they're on call, which Mr. Hollins was. So because of that vagueness in their policy, we don't have enough to establish that.
Thank you for the clarification. That's a helpful piece of information for me. I appreciate it. Colleagues, any other questions for our investigator? Okay, you've heard the report in the recommendation. Mr. Hollins, this is your chance to make any comments to us you choose to make. Please proceed, and if you make comments, identify yourself for the record.
Yes, I do. My name is Robert Hollins. I just wanted to just appreciate the opportunity to speak to you all. Just want to iterate that the provision that allowed me as a detective and as a police officer, I was on call since 1995 and has been on call as one of the hardest workers. I was on call for a crime. I was on call for a crime scene. I was on call for robbery. I was on call for crisis negotiation. I was on call for as a supervisor, and because I was even on call for officers and detectives who didn't want to be on call, so I was on call the entire time. There was never ever an issue related to that until I spent 31 years as a police officer and detective. There was never an issue until my final year in there, and the car had some mechanical issues. There was never an issue how far I live. I live almost 60 miles away from Portland. I drive and commute both ways. There was never an issue, never concern until this issue happened. There was an individual who had a problem with me, and it was an issue. And I filed a lawsuit, and we settled it. And this was pretty much racially motivated because I'm an African American male, and who devoted my entire life to dedicating and working for citizens and protecting them and doing all I could. I mean, I had a work-life balance that was more for work my entire time. And, I had 7 surgeries as related to that. I could have retired back in 2006 when I was injured on duty. I continued to work until 2019 in a diminished capacity as far as my physicality. But I dedicated my life toward enforcement and protecting the citizens of Portland. And, this was all an attempt to try to discourage my ability, try to blackball me so I couldn't work again. And, I was successful in overcoming that. And I appreciate the fact that when the investigator looked at all the circumstances of the situation, total of the circumstances, they ruled to dismiss. Additionally, when the issue came above, they never had an issue. I devoted my entire life to providing so I could be available. I mean, I was the one that who would leave my family event to go there because the stipulation was as long as you were willing. The only stipulation was you use the car for personal use, but you had to respond to on call 24/7, no matter what you were doing, no matter what was going along. I did that every time. Always responded. I responded when they said I went down to the coast. I responded. I responded that evening on a gun charge. I came, responded, and I lived, like I said, I lived 60 miles away from my place of employment, and I dedicated. I never had an issue. 31 years. Never had an issue with the police bureau. Never had a problem as far as being investigated for anything. Because I gave my life toward it. I have partial paralysis now to this day. That I could have left in 2006 for them to run me through this thing and try to discourage and discredit me and make me look as though I'm using a car for my personal gain, which is not true. I gave my life toward the police bureau, and I appreciate the opportunity to speak on that. And I hope you all follow the rule, the suggestion of the investigators, because it just so happens they changed the policy after this happened. They changed, made the policy more vague, more specific. Now you can use the car while you're on call, but now it says minimal usage, and you have to have a sergeant check your car out, because they never even checked the car out. The only reason this came up is because the car had mechanical issues at the end of the stage. Again, I have an immense career with the Portland Police Bureau. Still love the police bureau, but what they did to me was wrong. After serving 31 years, I gave to them, which was a detriment to my family, because I put service in this community before everything. That was my job. That's what I love doing. I still love it. I'm 62 years old today, and if I could go back today, I would go back today, even in my diminished capacity physically. I would do it because that's what I enjoy doing. So thank you for letting me talk and speak, and I appreciate the opportunity. Have a good day.
Thank you, Mr. Hollins. Appreciate your comments. Thank you for being here. Colleagues, any questions for Mr. Hollins or our investigator? And the hearing and seeing none, let's move toward a decision. Anybody have a motion to make, Vice Chair? If you're comfortable proceeding, if not,
I do.
okay, thank you.
Yep.
Thank you.
I was just looking for the statutes because they're not listed on the agenda. So I hereby move that the commission find that the information before the commission is insufficient to infer a violation of ORS 244.0401, subsection 1, or warrant further investigation, and that this complaint be dismissed in the matter of Robert Hollins III.
Thank you, Vice Chair. Appreciate your attention to detail in that motion. Any questions about the motion, colleagues? Hearing and seeing none on item number 13 on our public session agenda, the administrator will call the roll, please.
Commissioner Payne,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner McCully,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Chair Fiscum.
Aye.
Motion passed 6-0.
Your colleagues, the matter has been dismissed. Mr. Hollins, thank you for your patience with our agenda today and for appearing. We appreciate your comments. Have a nice weekend.
Thank you, sir, and I appreciate it. Be blessed.
you.
Thank you.
Okay, colleagues, we'll move forward to item number 14 involving Mr. John West, who intends to, the former commissioner of Josephine County intends to be with us today, as will be the case with his attorney, Mr. Connor King.
And both of them are on.
They are going to be admitted, if not already so. Mr. West, Mr. King, can you hear me?
Yes, I can hear you. I hear you.
Thank you very much. I am Dave Fiska. I'm the chair of the commission. This is the time set aside for us to consider the report of an investigation in your matter, Mr. West. Our approach will be to hear a report from our investigator. We may have questions. We'll allow you and or your attorney to make comments to us as you've done before. Thank you for being here again. And then we'll move toward a decision on the matter before us. That said, Mr. Sullivan, please make your report.
Yes, thank you, Chair Fiscum and Commission. This is Investigator Josh Sullivan for the record. I'm presenting agenda item number 14. This is an investigation report for a complaint about John West, former Josephine County Commissioner. The complaint in this case alleges that Mr. West may have violated Oregon government ethics law by attempting to use his official position to obtain a financial gain by inflating the appraised value of a 320-acre parcel of county-owned land known as the Pipe Fork property, which is immediately adjacent to a section of land owned by Mr. West. And by doing so, Mr. West increased the valuation of his own property. The Josephine County Board of Commissioners held several executive sessions from September 19th, 2023 through April 23rd, 2024 to discuss and conduct deliberations concerning the sale of the Pipe Fork property. The information initially indicated that the parcel of land adjacent to the Pipe Fork property is owned by John West through his business, Cascade Land Holdings. John West was an owner and an agent for Cascade Land Holdings. In 2020, Mr. West traded his shares of Cascade Land Holdings with a Bill Mielke for ownership of another company, Galease Mining Group. However, Mr. West remained the registered agent for Cascade Land Holdings. The information available establishes that as its agent, Mr. West had a conflict of interest with respect to Cascade Land Holdings, and that Mr. West failed to disclose his conflict of interest in violation of ORS 244.120 sub 2. There is no evidence to suggest that Mr. West used his office to raise the value of Cascade Land Holdings property. Rather, the county performed a property appraisal of the Pipe Fork property, which was higher than the appraisal performed by the Conservation Fund. There is no evidence to suggest Mr. West interfered with the appraisal. Mr. West, as a commissioner, participated in meetings related to negotiations of the Pipe Fork property and the value of the property. Participating in meetings alone, however, does not indicate that Mr. West used or attempted to use his office to create a financial benefit for himself or a business with which he is associated, which would not otherwise be available to him, but for his position. Therefore, there's not a substantial objective basis to believe that Mr. West violated the provisions of ORS 244-040 sub 1. The information available establishes that Mr. West failed to list Galice Mining Group as a business on his SEI disclosure in violation of ORS 244-060 sub 2. Mr. West is the admitted owner of Galice Mining Group, and it is required as the SEI filer to disclose their business. Mr. West did not disclose Galice Mining Group as a business on his SEI filings. Based on this information, the Oregon Government Ethics Commission should make preliminary findings that John West violated ORS 244120 sub 2 by failing to disclose a conflict of interest as an agent of Cascade Land Holdings, and ORS 244060 sub 2 by failing to list Galice Mining Group as a business on his SCI disclosure. The Government Ethics Commission should move to dismiss the allegations that John West may have violated ORS 244040 sub 1 relating to using his office for financial gain.
Thank you for your report, Mr. Sullivan. I have a quick friendly question for you in a moment, but I'll see if my colleagues have any questions for you based on your report. My question is, if we were to go with your recommendation, there would be two motions. One to proceed, one to tell me what the two motions would be.
Yes, the one would be to make the preliminary findings for the conflict of interest and the SEI violations, and then to dismiss the prohibited use of office filing.
Thank you. So there would be, if we follow your counsel and advice, two motions that we would be considering.
Yes.
Thank you very much. Questions on that, colleagues, before we proceed to our respondents? Okay, hearing and seeing none, Mr. West and Mr. King, this is your chance to appear before us. Thank you for being here before. You know the procedure today, so either or both of you may speak for a few moments, and please, as you do so, any order you choose, identify yourself for the record. Thank you for being here. Please proceed.
Thank you, commissioners. My name is Connor King. I'm Mr. West's attorney, and I'm here representing him today. Mr. West may make a few comments after I'm done with my response. That said, I will go ahead and get into it. There are recommendations regarding 3 items. I'm going to go through each one. It sounded like you had mentioned 2, but it's based on the report. I thought it was 3. The first is that John West allegedly violated ORS 244-120 sub 2 by failing to disclose a conflict of interest as an agent of Cascade Land Holdings. The letter accepts that John West no longer holds any ownership interest of Cascade Land Holdings and has not held any such interest since January of 2020. The letter accepts the fact that Cascade Land Holdings was dissolved in 2016 pursuant to the authority of the Secretary of State. Mr. Malicki, the owner of Cascade Land Holdings, in an interview with the investigator, sorry about that, stated clearly that Mr. West is no longer involved in Cascade Land Holdings Incorporated or the associated property. Under ORS 60651, the Secretary of State dissolves a corporation if 45 days after notice is given for the grounds for dissolution, no response is received. So the Secretary of State dissolved the corporation. I believe it was January of 2016. The allegation is that Mr. West is somehow an agent of Cascade Land Holdings. In the case, Supreme Court case, Figuera v. BNSF, it's case number 361 OR 142. The Oregon Supreme Court stated that we conclude appointing a registered agent to receive service of process merely designates a person upon whom process may be served. It doesn't constitute implied consent, and this was a jurisdictional issue. Under the Supreme Court's formulation in Vaughn v. First Transit Incorporated, 346 OR 128, the court stated to be an agent, using the well-defined legal meaning of that term, two requirements must be met. The individual must be subject to another's control, and the individual must act on behalf of the other person. There is no evidence that Mr. West was subject to the control of Cascade Land Holdings, or that he is required to act on behalf of Cascade Land Holdings to the extent that such a corporation even exists. Now that we're 9 years late, now that it's been 9 years since the corporation was dissolved. Being a mere registered agent for a corporation does not constitute a conflict of interest or a potential conflict of interest under ORS 244.120. Just as an example, as a final point on this issue, there are corporations like CT Corporation that operate as registered agents for many companies in the state. If a let's say an officer of CT Corporation was a member of a board, and a complaint was made about a company that was dissolved 9 years ago, for which CT Corporation was still the registered agent, would there be somehow a conflict of interest there? That seems highly unlikely. So I don't believe there's any basis to construe him as an agent as Mr. West is an agent under ORS 244.120, or I guess the definitions of a business under ORS 244, Chapter 244, and I don't think there's a conflict of interest here at all. The second issue is that the report alleges that John West violated ORS 244.060 sub 2 by failing to list Galice Mining Group as a business in his SEI disclosure. First, any investigation into Mr. West's alleged ownership of Galice Mining Group or property on Galice Creek Road is outside the scope of the OGEC's investigation, the Government Ethics Commission's investigation. There is no mention whatsoever about the Galice Mining Group in the preliminary review, and the complaint mentioned nothing about Galice Mining Group. Under ORS 244.260 sub 5 sub B, if the commission makes a finding of cause to undertake an investigation, the commission shall undertake the action in the investigatory phase. The commission shall notify the person who is the subject of the investigation, identify the issues to be examined, and confine the investigation to those issues. If the commission finds reason to expand the investigation, the commission shall move to do so, record its minutes, the issues to be examined in its minutes, the issues to be examined before expanding the scope of its investigation, and formally notify the complainant. In this case, the commission apparently, or there appears to be from the report, that there was some kind of decision to expand the investigation into a general evaluation of Mr. West's SEI filing and his alleged ownership of Galice Mining Group. I think that's far outside the scope of the complaint, which only alleged that Mr. West was trying to inflate the value of the Cascade Land Holdings property adjacent to the Pipe Fork property being discussed by the Josephine County Board. It's not only far outside the scope of the complaint, but also outside the scope of the preliminary review. I mean, Galice Mining Group is not even mentioned, and there's no indication that there's any failure of the SEI filing, or that Galice Mining Group is not properly, or the Galice property is not properly reported therein. There was no notice, as I mentioned, prior to the investigation report that we received 2 weeks ago, that Mr. West would need to defend himself against allegations regarding Galice Mining Group. There was, says, regardless of that, the investigative report states clearly that John West's 2023 and 2024 SEIs identify the property allegedly associated with Galice Mining Group, i.e. account number R306421 in section 3 under real property. So the property at issue that is supposedly owned by Galeese Mining Group is disclosed in Mr. West's SEI filing. So he did disclose that, and the fact that Galeese Mining Group was not listed makes common sense, just because it's been dissolved for almost 15 years. There's also no requirement that a person disclose administratively dissolved businesses, which are not permitted to transact business in Oregon. The requirement is to disclose economic interests, and the requirement to disclose economic interests generally pertains to active positions and sources of income. The dissolved company no longer provides, if the dissolved company no longer provides income or holds active business positions, it may not fall under the required disclosures. Furthermore, there's no issue of prejudice or here. I mean, regardless of whether Galeese Mining Group actually legally exists, it produces, there's no evidence in the report that it produces any income to Mr. West. And he did disclose his ownership of the properties, which are at issue here on Galeese Creek Road. Finally, the investigative report states that the SEI requires the filers to identify their businesses, including all businesses for which they are a member or of their, for which they or a member of their household serve as an officer or director during the preceding calendar year. This formulation is incorrect. The SEI filers, the SEI requires filers to list any businesses in which they are a member of their household as a member, or has maintained as a position as an officer or director. It doesn't just have a blanket requirement to identify all businesses. It requires them to, the report contains no evidence that Mr. West conducted any business via Galeese Mining Group or Cascade Land Holdings since at least 2021, nor does the report contain evidence that Mr. West is an officer or director of Galeese Mining Group or Cascade Land Holdings. As indicated in the report, the SEI also requires filers to list all sources of income that make up 10% of the total annual household income in the preceding year. There is no evidence in the report that Galeese Mining Group or Cascade Land Holdings make up 10% of Mr. West's total household total annual household income in any calendar year. The SEI also requires filers to list all property they own in a certain geographic area, which, as relevant here, is Josephine County. Mr. West listed the property allegedly associated with Galeese Mining Group in his disclosures. So the property was disclosed as required. Finally, there's an allegation that Mr. West violated ORS 244-040 sub 1 by using his office for financial gain. The recommendation there is that it be dismissed, which I imagine the commission will follow. That said, that is the actual crux of the complaint. That's what the complaint was actually about. And it's quite clear that Mr. West no longer has any interest in Cascade Holdings, in Cascade Land Holdings, or the property involved with Cascade Land Holdings. And the fact that he's still listed as a registered agent for a company that was dissolved 9 years ago is a simple clerical error. The owner of Cascade Land Holdings and that property was clear that he has no involvement whatsoever in the company or that property any longer, and hasn't since at least 2020. So for the reasons set forth above, I believe the entire complaint should be dismissed, and the commission should dismiss every allegation basically made against Mr. West in this respect. Thank you.
Mr. King, we may come back to you with the questions. I want to just move quickly to Mr. West and see if he has any brief comments to make in addition to what you've said. Mr. West, feel no pressure to do so, but this is your chance. Briefly, please.
Yes, sir. Thank you. This is John West, former county commissioner. My commissioner ended on January 8th of 2025. I've dove into this subject because it just kind of mind boggled me a little bit. And I was looking up and it says no person is generally not considered a registered agent for a corporation once it's no longer in exist. When a corporation dissolves, the registered agent role also terminates, meaning there are no longer legally responsible for receiving service or process on behalf of the defunct company. And then it says key points to remember. Registered agent functions ends with the dissolution. The primary role of the registered agent is to accept legal documents on behalf of the company. And once the company is dissolved, there is no entity to receive those documents, making the registered agent position obsolete. So with that being said, we're discussing Cascade Land Holdings, which was dissolved in 2016. A final IRS tax return was filed in 2017, the final tax return, and the whole corporation is gone. So any member of the board here, anyone, if that name is available, could file anytime for that exact corporate name. That doesn't make me the agent of it because it says that I'm an agent of a defunct company. So and then in 2010, Cascade Land Holdings was dissolved and its final tax return was filed in 2011.
John, do you mean Galease Mining Group in 2010?
Galease Mining Group, I'm sorry. Galease Mining Group was dissolved in 2010 and the final tax return for Galease Mining Group was prepared and received by the IRS in 2011. And so, but on my forms, I don't list as an agent because under perjury, every form I sign says under perjury that you're supposed to make sure your documents are true and accurate. And I don't list it because those companies don't exist. And I don't want to list that I'm an agent of something that I'm not, one, and two, and I'm not an agent of a company that don't exist. So I'm a little bit confused with that. There cannot be anything that ties me to it. So that's all I really have to say. I was just really confused with all of this.
Thank you, colleagues, commissioners. This is now a chance to ask any questions of Mr. King or Mr. West. As you please, if you choose to do so, just let me see your hand. Hearing and seeing none for the moment, I'm going to ask our investigator or our director if he or she has any response to what's been said to us in the last 15 minutes. You may have some responses and we'd love to hear them now, please.
Thank you, Chair. And I may turn to our attorney to address the dissolution issue. But I would point out that the Galease, it's not like we went looking to find anything about Galease. The sole reason that matter came before us is that Mr. King and Mr. West produced a document saying that in 2022 or whenever it was, which apparently was 10 years after both of these companies, many years after both companies ceased to exist, that Mr. Mielke and Mr. West did an exchange of interest in these companies, in these businesses, so that Mr. West would no longer be an owner, officer, or director of Cascade, and Mr. Mielke would no longer be an owner, officer of Galease. So this idea that we expanded business is expanded the investigation. All of it is based on the information that you provided to us.
If I could add on to that, the preliminary review report did include ORS 244060 as statement of interest as something that we would look into in investigation.
Yes. And then Sean can address the administrative dissolution of a corporation versus an actual dissolution of a corporation.
Counsel, please.
Well, I don't know if I can do all of that. If there's a question, I
Good
can
answer.
try to answer, but generally speaking, an administrative dissolution at the Secretary of State is basically a failure to renew or a failure to register. They send notice, and if you don't respond, they'll administratively dissolve, which means that the company can no longer legally transact business in Oregon, except to unwind or wind down their operations. I cannot speak to what occurred with respect to either one of these corporations, so I'm not speaking at all as to what occurred with these corporations. There is a provision that says that administrative dissolution does not terminate the authority of the corporation's registered agent. And as was outlined here, Mr. West was registered as the corporate agent for the one company, Cascade.
Thank you, counsel. Executive, anything else, investigator? Not that there needs to be. Thank you. Colleagues, we can discuss how to proceed if there are more questions to ask in light of anything you've heard of those who appeared before us or of our investigator or director or legal counsel. Now's the time to ask questions before we think about how to proceed on these matters, meaning two matters. There would be two issues before us as recommended by our staff. So questions for you as to how you'd like to proceed. Any comments? Mr. Thompson, please.
I very much understand Mr. Brady's comments about administrative dissolution, but what tips me over the edge on this is that final tax returns were filed for both of these companies. So I'm inclined to vote to dismiss all three of the ORS violations that are, I know one has been recommended for dismissal already. I'm inclined to vote to dismiss the other two based on the fact that the final tax returns were filed, and in my mind, I don't think those entities existed anymore.
Thank you, Commissioner. Comments from colleagues, director, feel free if you have any, not saying you need to have some, but if you have some, please feel free. Colleagues, questions, comments about the motion that might be made? The possible motion that might be made? Concerns, questions, comments? If you're ready for a motion, we'll accept the motion. Vice Chair, you can defer to others if you would prefer that method this time.
I would defer to others.
Thank you. Mr. Thompson, please.
Mr. Chair, I hereby move that the commission find that the information before the commission is insufficient to infer a violation of ORS 244-120 sub 2, ORS 244-060 sub 2, and ORS 244-040 sub 1, or warrant further investigation, and that this complaint be dismissed.
Thank you for the motion, Commissioner. Comments on the motion before us as made by Commissioner Thompson? Director, any comments on the motion that you've heard?
No.
Thank you.
Every time I say something, you ask like she's me. I'm starting to get a complex over here.
I really asked that question to make sure your citation of statutes
Okay.
involved.
Fair enough. Fair
So
enough.
that's my, thank you for the clarification.
I'm just giving you a hard
Commissioner.
time.
I know you are. My question to the director was to make sure that if this motion were to proceed, the statutory citations are in fact correct.
Yes, those
Thank you
ones
very
are
much. I appreciate for that. Colleagues, are you ready for the question? I'll assume with no hands raised that the answer is yes. So in light of the motion before us as to dismiss in summary all, as evidenced by Commissioner Thompson, the administrator will call the roll on item 14.
Commissioner Resendez Gutierrez,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Payne,
Aye.
Chair Fiscum.
Aye.
Motion passed 6-0.
Mr. Keegan, Mr. West, you've heard the motion just made. That means the matters, plural, have been dismissed. Thank you for your participation this morning and this afternoon. by a half hour. We appreciate your attendance and your patience with our schedule. The matters have been dismissed. If you have any questions, please talk to our staff.
Thank you. Thank
Thank
you,
you.
commissioners. Have a good afternoon and weekend.
Thank you. Okay,
Thank
colleagues,
you.
we will forge ahead. I'll make just a couple of brief comments on correspondence received. As always, you should read those as I do. Interesting information contained in all of those pieces of staff advice, including the one for the Attorney General resolving his own practice as he moves into the government office. The next items are miscellaneous, and in several of those cases, there may be discussion. The first item is number 19, discussion regarding advisory opinion, own motion regarding ASOSU Judicial Council Director.
Yes, thank you, Chair. As the commission may recall at the commission's December meeting, there was a case in preliminary review, and in the course of the case, the question was raised whether the commission might achieve more in that case by issuing a commission advisory opinion on its own motion. And the commission does have the authority to do so. So initially this was placed in the meeting book for the commission to decide if they want me to prepare such an opinion. As I explained in my memorandum, after the meeting, we did reach out to the attorney for OSU to see if they wished to simply request a commission advisory opinion. We had some discussions, and then we did not receive any such request. However, in the 10 days since the agenda item went out, I was contacted by Miss Leanne Reeves, the attorney for OSU, who did indicate to me earlier this week that they are preparing a request for a commission advisory opinion and should have it to us by February 7th. So you could proceed to direct me to do it on your own motion, or we can wait for her to submit the request.
You have a preference as to that from your vantage point?
Probably wait for her to submit.
That'd be my first blush, but I submit to your guidance. Okay, so at the moment on this matter, nothing is necessary for our action. Colleagues, are you comfortable with that approach for this matter? Thank you. I see heads nodding in the affirmative. That's good. We'll now move to item number 20, which I think deserves a little bit of discussion from all of us. I'll turn to the executive first to make a report on this item.
Yes.
Chair, I have an announcement that I need to
thank
make
you.
for this matter.
Vice Chair, I forgot to refer to you, so now's your chance, please.
Great, thank you. I have no statutory conflict, but I do need to just recuse myself from voting or discussing this matter as I'm currently under consideration for an appointment by the governor, and I just want to avoid the appearance of any impropriety.
Vice Chair, thank you for your comment. I forgot to recognize you. I knew it was coming, so we appreciate the way you phrased that issue for yourself, and we respect it, as I've told you before. So thank you for making that comment. Director, please, side of the Secretary of State letter.
Yes. So item 20 in your meeting books is a letter that the Secretary of State issued to the governor's office and sent us a copy of their hotline. They had received a anonymous hotline report, and they conducted an investigation.
Which they're required by law to do.
They're required by law to do, and at the end of that, they are required by law to send us a copy.
Thank you.
During the course of their investigation, I spoke to them several times about the provisions in 244.040, the exceptions, etc. The letter, as you can see, identifies some what they considered questionable activities involving parking, involving some tickets, and involving a reception at Mahonia Hall, and recommends to the governor's office that they tighten up some policies and so forth. So, a couple things that I want to bring to your attention here. One, the Ethics Commission has no authority over the governor's office. We have no authority over public bodies. agencies, cities, the governor's office. That's not how it works. The laws in Chapter 244 don't apply to the public bodies. They apply to the individual public officials. So that also means we have no authority over how another public body spends its money. What we have authority over is when an individual public official violates one of the laws in Chapter 244 by making decisions that would have a personal financial impact, or using their position to obtain something they wouldn't otherwise be entitled to. So, keeping all of that in mind, the letter from the Secretary of State's office is not a complaint. The Ethics Commission has not opened any case because we don't have that complaint. But it does identify certain issues. One of the issues for me is that some information may be incomplete. For example, the parking issue. I can share some additional information that I am aware of. So the governor has a parking space at the Capitol provided to the governor. That's not an issue. That parking space, the governor can, under administrative rules, all employees who have parking spaces can allow other public officials to use those parking spaces. You are allowed to sublet your space. Can't make money on it, but you can sublet the space. There is a DAS administrative rule that specifically says that. There may be additional information to gather as to these particular spaces, but that is my understanding. The issues for us are that, one, we don't have a complaint, so we would have to do an own motion. That an own motion would not be an own motion against the governor. It's the people who did something that was for personal financial benefit. So the question would then be, would we do 180 own motions for everyone who attended the reception at Mahonia Hall?
Since Commissioner Payne has recused herself, no. It's a lot of motions.
Yeah, I mean, it would be a lot, and then one, there are potential exceptions for that reception that would apply, that allow people to accept,
Right.
a meal or a gift or something at a reception that is celebrating a year of service or whatever.
Just for further comment, at the moment, we have there's no idea of that 180,
No.
who composes that 180, and whether those who were part of that Mahoney reception,
Did they?
historically done or not, were they public officials?
Yes.
Because some of them may not be, quote, public officials, which are within our jurisdiction. So I'm amplifying your comment. Please proceed.
This stage, our options would be the commission could direct me to gather information for an own motion that we would have to bring back to the commission.
Right.
Right now, I don't think we would meet the level of having enough information to even bring an own motion.
Right.
One of the other possibilities, the commission could also, as the Secretary of State's office has already provided some advice and guidance to the governor's office on improving their policies, the commission could direct me or staff to prepare. One of the suggestions was we could prepare a commission advisory opinion. I'm not actually so in favor of that, because what has been revealed in all this isn't all that clear that we would be providing any new advice that isn't already out there. My proposed alternative is that the commission could simply direct me to invite the governor's office to request advice from us, specifically as to, one, getting a better understanding of 244040 and the exceptions, but also asking us for advice on whether the steps they are taking in response to the Secretary of State letter would satisfy any requirements under the ethics laws. So,
Colleagues,
the commission, but that's my preference.
thank you. Colleagues, some of us have had this letter for a few days and have had a chance to review it. Thank you to the director who's given us some quick comments, which I appreciate. I think is that time is now for us to discuss what we do with this. I would add the words, if anything. I have some comments on that, but I will yield to my colleagues, in particular, Commissioner Resendez Gutierrez. Please, your hand is up.
Yes, thank you, Chair. I appreciate Susan's comments. I am in favor of the first option that you presented, Susan, about asking you to collect more information. The letter that I read, dated January 2nd, 2025, that's in the materials. There's a lot of questions here, and that there's information missing from it. In that, as you pointed out, that I would like more information before I consider making a motion to move forward with an investigation. So that's my preference.
Thank you, Commissioner. Any other comments from colleagues? Commissioner Gutierrez and me? Let me make a couple comments. After reading the letter in more detail over some days, I have come to a tentative conclusion, subject to interaction from colleagues, that we need to take some kind of action in response to the letter without just letting it lie fallow. We've heard what a hotline investigation is, and the audit staff in the Secretary of State's office responds to hotline investigations, and found in this case that the original allegations were not to be founded, not found to be accurate, but the Secretary of State audit staff found other issues, and the letter to the governor apprises the governor and her staff of cases where they need to adhere to state government purchasing and financial policies. But the letter also outlines a couple of cases where there may be ethics issues involved. And if that may leaves the issue, I think, to us to at least, in the commissioner's words, get more information, or at least not, let me do a double negative, not to do nothing. The three examples of potential problem areas from an ethics standpoint of the parking issue. We don't know for how long those parking fees on a monthly basis existed. There was the reaction of the second issue of folks who went to events where they could have been receiving issues gifts above the gift limit. And then the Mahoney issue, which, as we've talked about, is so complicated as to be almost unintelligible, frankly, with regard to the 180 individuals who were reported to be there without names. Or is there some kind of other option for us to consider, short of own motions, that would be an advisory letter? Maybe the word advisory needs to be removed from my lexicon, and say a letter to the governor's office to say, we've been apprised of these issues that might exist. Please have your staff, please, you and your staff pay attention to these issues. There is language that you can read in the letter that may have violated ethics law in 244040, et cetera. So I think we can't just let this lie alone, and I have not necessarily an exact answer about what to do. And I'm not trying to find something to charge the governor with, but if we were to move on own motion bases in these issues, it wouldn't be the governor's conduct, as our executive has stated, which was an issue anyway. It was the receivers of the parking. It was the receivers of the gifts above limit. It was receivers of largesse at the Mahoney Hall reception, not the governor. So I can not settle for, but I can accept the Commissioner Resendez Gutierrez's idea I'm happy for further discussion in the moments we have left before we exceed our time allotted.
So if the commission would like me to gather more information and bring it back to the commission at its March meeting, I can do so. That information would either be information in support of an own motion, of a possible own motion against one of the varying people, or information that would be in support of some form of an advisory letter
To the governor's office.
governor's office relating to application of chapter 244 to the types of items identified in the Secretary of State audit.
Comments about the director's remarks? Anybody?
Yes, this is Commissioner Resendez Gutierrez. Yes, so my preference would be for Susan, I'm not prepared to say whether we want to move forward with an investigation or move forward with an advisory letter, but I think that the motion would be that we authorize you to go collect more information for us to make a decision on that, including but not limited to potentially making a motion to investigate or making a motion to get an advisory opinion or issue an advisory letter.
Mr. Thompson?
Yeah, thank you, Mr. Chair. I was curious, Director Myers, if we could investigate DC for their 18% parking tax. Don't answer that. Don't answer that. But no, I agree with Commissioner Resendez Gutierrez. I think we need some more information, and then I would respectfully add to his, once you gather that information, a recommendation from you on whether we should go own motion or advisory opinion based on the information you gather.
And that would be fine.
Because I'm with our chair. I think, especially with the Mahonia reception, I don't even know how you would start investigating that other than having to hire like 10 more people to do it. So
Okay.
I may have staff for.
yeah,
Revolt. Director, I think we need to have a motion to that effect to authorize you or direct you.
I don't think, I mean.
Do we need a motion?
Have a motion.
Legal counsel?
Directly.
Would it be helpful to have a motion, legal counsel?
You can do either way.
We paid for that.
but do we pay 18% parking tax for
Certainly
that?
a motion has more weight than just a conversation.
Commissioner Resendez, thank you. Commissioner Resendez Gutierrez, please make a motion.
Yes, thank you, Chair. I hereby move that the executive director move forward with collecting more information regarding the allegations in the January 2nd, 2025 letter to the commission in order for us to determine what steps to take based on that information, and for the executive director to provide a recommendation on next steps based on that collected information.
Yeah, Commissioner, anybody question on the motion? Is that adequate for you? Okay, we're ready for the question. The administrator will call the roll on the motion made by Commissioner Resendez Gutierrez relative to the Secretary of State audit letter to the Governor Kotek. Please.
Commissioner Thompson.
Aye.
Commissioner Payne. Oh, sorry, shoot.
Abstain.
Commissioner Resendez Gutierrez.
Aye.
Commissioner McCauley.
Aye.
Commissioner
Aye.
Fiscum. Motion passed 5-0 with 1 abstention.
Thank you, colleagues. We will forge ahead on a couple more matters on our public session agenda. The first is the training report, and I'm going to look at the training report person today, whomever that is.
For the record, this is Trainer Lex Chingy, and I'll be sharing the training report for last month, or for this month, excuse me. So one of the biggest things is that we have all of our 2024 training data, and if you had a chance to look at that, the numbers are pretty impressive. We trained almost 17,000 people in 2024, and our in-person people grew by about 40% as well. So we fully expect those numbers to be even bigger in 2025, especially as we'll have a full year of public meetings law trainings. Communications-wise, our 50th newsletter went out last month. It was a newsletter that all of the staff worked on. Ruth, another trainer, was our point person and helped us edit that. It had an interview with former staff, Virginia Letts, and our former executive director, Ron Burson. And we actually had a 69.2% open rate, which is amazing engagement. And for all of 2024, we did have an open rate of 41%, which is also amazing engagement. Usually in marketing, you're happy with like a 10, 12%. So we're doing very well in our communications. As for training outreach, January kicked us off with a ton of travel trainings. Charlie and I started with Southern Oregon. We had Southern Oregon University, City of Phoenix, Central Point, Jackson County, all kinds of cities and counties there. We've had some individual trips. Chris and Ruth are actually on a trip to Gilliam County right now. They were in Hood River today. So we have been all over the state already, and we are booked through March currently. April's probably almost booked as well.
April is also booked.
Yeah, April's booked. So it's going very fast. And what's really great is we're able to open these up to the public. So when we are visiting an area, we're able to train public officials from all over. So, and some of them do travel even an hour to these trainings. So we are also working with our relationships with associations. I presented public meetings law for the Association of Oregon County, their county college, and Stephanie will be presenting for the Special Districts Association of Oregon next month as well. Molly has been an incredible help with our training schedule and coordinating with these public bodies to get these trainings on the schedule. It is a lot of work to do that. So like I said, we're booked. And at one point, we actually had 18 different registrations available on our in-person. I won't be surprised if we surpass that. So, and along with those trainings, we are preparing for the Statement of Economic Interest season, SEI. It's right around the corner. Our webinars are already posted there's a couple times for SEI and JC where we'll be doing daily trainings to help public officials prepare for that. And we'll have updated and accessible guides on our website at the beginning of February for that. And then just a staffing note, with the help of our leadership team and pre-planning, our training team did survive Stephanie being away, but we are very happy she's back and we are excited to face the year with a full team. So thank you.
And I just want to add
Let's
on.
take a vote on Stephanie's being back. All in favor, say aye.
I'm not. I do just want to thank the staff and my colleagues for picking up all the pieces while I was out. But I wanted to point out that with that increase in training numbers, a couple of things. And the first is that our trainers were not trained and up to speed for several months of the beginning of this year. And public meetings law trainings did not start until October. So that growth we can say it was in part because of public meetings law, but that doesn't really tell the whole story. There was a lot of government ethics law trainings happening. And there's becoming a greater and greater demand for online, kind of like on your own trainings through Workday. And so we are going to be working this year on focusing on trying to get the public meetings law training available in that format as well, just to increase the accessibility. So that is one of our big goals for this year.
Thank you. Questions on training issues? Thank you for the report. I know things are picking up and that's part of our mission, education and training, as we all know. So thank you for all that. Good work. Executive Director's report is the final step in our process today. Please, Director.
I will start with sort of highlighting what staff, everyone knows we have been incredibly busy and we have seen an increase in the numbers of the statistics here, a 31% increase in the numbers of cases and complaints. As Lex pointed out, a 40% increase in the number of in-person trainings, and big ampersand here, an 82% increase in the number of written pieces of advice we issue. Vast majority are emails, but everyone is answering questions. People have questions, not just about public meetings law, but about ethics. How am I supposed to disclose my conflicts of interest? So simply want to highlight that. Couple points for the commission. Budget. Our budget has been assigned a bill number, and in fact, we have a hearing date. It is on February 10th.
Which is an overview presentation, not a decision.
Right.
you'll know.
It's the introduction of
Right.
the budget. So, Chair Fiscom will be appearing via video at that hearing. Legislative session has obviously begun. The hearings on the initial introduction of the agency to the rules committees in the House and Senate, and hearings on our 5 legislative concepts, our 5 bills, have also been scheduled. So on Monday morning at 8 a.m., horrible hour, Becky and I and Chair Fiscom will be appearing before the House Rules Committee. And then the following week, on Monday at the 3rd at 1 p.m., we will be appearing before the Senate Rules Committee. In addition to our 5 bills, we are actively tracking other bills, and I believe Becky has provided the commissioners with our initial list of bills that we're tracking in Bill Tracker. If you come across any bills that you think we need to know about, please direct it to our attention. I also need to remind you about any lobbying that any of the commissioners undertake. While the commissioners and we are allowed to lobby for our own bills, if you are going to engage in any sort of communication and lobbying on any other bills, there is a process. There's a form we have to fill out with the governor's office, and they would ask that if you're out there taking a position on some bill, that you make it clear you are not speaking as a representative of the commission. We have, as you know, the 2 vacancies. Our understanding is that the Senate Republicans have nominated someone who will go before the Senate committee in February. So we should have 1 additional commissioner by the March 7th meeting. The other vacancy is likely not to get filled until May.
Case updates.
So OLCC and Sagan, I know there are questions about those cases. We have been in active negotiations with the attorneys for the OLCC respondents to see if we can reach agreement on language for a proposed stipulated final order. We are continuing that process. If that is successful, we will bring the STIPs to you. If not, hopefully at the March meeting, we would bring the investigative reports. Fagan cases, as you know, they were time waived because there was federal investigations going on. We were contacted by Ms. Fagan's attorney that the need for a time waiver had ended, and therefore we have reactivated those investigations. Our timeline, I believe, ends in May for those.
Our clock has started again.
And that is
That's a 6-month clock, is that right?
yes, though some of that clock got used.
I know, so that's a total of 6, but whatever you mean.
Till
Yes,
I think the
thank
end
you.
of May.
Thank you. Any questions for the executive? Good report, thank you. Colleagues, anything else for the good of the order?
You gonna get Fiscom some training on how to testify before legislative committee? I know it's new to you.
I have a comment I could make to you, but for the record, I will restrain myself. Colleagues, Mr. Payne, please.
Yeah, so a couple comments for improvement and suggestions for staff moving forward. I find it very helpful to have the statutes listed in the agenda as the person making the motions. So if we could have that moving forward, I would very much appreciate that. I was also wondering if it was possible to have the investigator listed in the investigative reports as to which investigator did the investigation. As a person who's not sitting in the room and not seeing like the nameplates and who's speaking, sometimes I don't I can't follow which investigator did which investigation. And so I think that would be helpful for those of us who aren't sitting in the room, especially because we have some newer staff, and it would help me get to know our newer investigators to have their names listed on the investigation reports. I think that would just be helpful. If there's a problem with that or a reason why we're not doing that, I would respect that decision, but I think that would just be helpful to those of us that aren't in the room. Those are my suggestions.
Definitely a valid point on the statutes and the agenda, and we will try to correct that. Listing the investigators in the reports, it's a little tricky for a number of these cases because the initials were originally intended to help identify the investigator, right? ESM would be ethics case Susan Myers. Problem, of course, is that when the cases don't originate with an investigator, the initials belong to the prior investigator or prior investigators, and we can't change the initials. The investigator's name is at the very end of the report because under the signatures, it gets signed by the investigator, by me, and by DOJ. So that would be the most current investigator, but I can explore if there are other ways that we can highlight who.
Vice Chair, that's what I was going to say. In many cases, the investigator's name, which I've tried to find, is at the end of the report after the citations of what's included. Don't misunderstand my point. I think if there's a way to more prominently display the investigator's name, and that would be. I'm open to those suggestions because I think that's a good report, especially when folks like Commissioner Payne can't be in the room like I am. So thank you for those suggestions, Commissioner. Any other comments for the good of the order? Hearing and seeing none, we will.
What we could do is on the agenda, we could just add the investigator right there on the agenda.
That'd be great.
That'd be easier.
Good idea. Commissioner not Commissioner Mason.
It's actually Stephanie's idea.
No, there's ways to make those improvements, and so the staff will follow through. Commissioner Payne, thank you for that. Colleagues, we now stand adjourned at 12:58 and 42 seconds.
You made it by one, only an hour late.
Since 1 o'clock and 1 o'clock.